Red and blue lights flash in your mirror. You pull over to the side of the road. The officer returns your documents along with a warning and then simply stands there continuing the conversation, asking questions, glancing around the interior of your vehicle. The overwhelming majority of drivers sit there and go along with it. They assume the officer is running the show. They respond to every question and surrender their legal rights without ever recognizing what is happening. The moment that ticket or warning is physically in your hand, the legal authority of that traffic stop has ended. Rodriguez versus United States. You are free to go. Three specific words that compel the officer to either release you immediately or provide a lawful legal justification for continuing to hold you there. Six critical mistakes people make when attempting to use those three words, and missing even one of them creates a gap that gets taken advantage of every single time. Stay with us through all six because each one builds on the last. During the first 30 seconds after being pulled over, activate your signal and move to the shoulder safely and deliberately. Leave your engine running. Shutting it off communicates voluntary cooperation and can actually work against your legal position. If the stop is occurring after dark, switch on your interior dome light so the officer has clear visibility into the cabin. Place both hands flat on top of the steering wheel, where they remain visible at all times. Lower your window 2 to 4 inches, just enough to pass documents through without fully opening it. Announce every physical movement before you make it. Tell the officer exactly what you are about to do. Detention becomes the foundation of a suppression motion filed by your attorney. The core lesson about remaining silent is this: formal verbal invocation is not optional once you have been told you are detained. Silence by itself is not a legally adequate substitute. Speaking those specific words out loud is what creates the legal record that protects you. But even when you invoke your rights with complete precision, officers have a specific and practiced follow-up move trained into their approach. And mistake number 4 is failing to recognize that move when it happens right in front of you. Mistake number 4 is failing to identify and correctly respond to officer evasion after you have already stated your question. This is the most sophisticated mistake on this entire list precisely because it does not look like a mistake when it is happening. In the moment, it actually feels like you are being cooperative and reasonable. Here is how officer evasion typically unfolds on camera. You have asked clearly whether you are free to go. The officer does not respond with yes and does not respond with no. Instead, they pivot immediately to a completely new question. They ask in a friendly and casual tone whether you have somewhere you need to be. You respond that you do not really have anywhere urgent to be. They say that is great and that it will only take another second before asking where you were headed this evening. That conversational pivot, the friendly and casual follow-up question designed to feel spontaneous and low stakes, is a documented interrogation technique. Officers receive specific training on the fact that once the formal purpose of the stop has been completed, if they can keep the driver talking on a voluntary basis, everything that driver says during that continued conversation is fully admissible in court. As long as you are still talking willingly, the encounter continues to appear consensual on camera. That is the legal gray zone they are actively working to keep you inside. In Berkemer versus McCarty, the Supreme Court established that routine questioning conducted at the roadside during a traffic stop does not constitute custodial interrogation for Miranda purposes. Anything you voluntarily say during that exchange is legally fair game for use against you. The instant you respond to that casual follow-up question, you have voluntarily re-entered a conversational encounter on your own initiative. The wrong version of this sounds like this. The driver asks whether they are free to go. The officer says to give them just one more second and asks casually where the driver is coming from tonight. The driver answers that they're just coming back from a friend's place over on a specific street in the area. That answer, your route, your precise location, where you had been, is now captured in the officer's notes and potentially in a recorded statement. Depending on what the officer suspects, that information may be more than enough to establish new reasonable suspicion to continue and extend the stop. Officers are trained to cross-reference the answers you provide against information they already have in hand. Even minor inconsistencies, no matter how trivial they appear, can become the stated justification for further investigation. The correct version sounds like this. The driver asks whether they are free to go. The officer says to give them just a moment and adds that they just want to ask a couple of questions. The driver responds that they have already invoked their Fifth Amendment right to remain silent and that they do not have any additional responses to provide. They ask again whether they are free to go or whether they are being formally detained. Stay completely calm throughout. Maintain your polite and measured tone. Do not engage with the new question on any level. Do not explain your reasons for not answering. Do not become defensive about your position. Simply redirect the entire exchange back to the single legally relevant question currently on the table. The core lesson about evasion is this. When an officer deflects your direct question by asking you a different question in return, that is not a natural continuation of conversation. It is a deliberate tactical move. You are under no legal obligation to participate in it. Redirect, re-invoke your rights, and wait for a direct and clear answer to your question. Every single second you spend responding to their new question is a second you are no longer actively asserting your own constitutional rights. Mistake number 5 is delivering your question with an attitude and handing the officer the precise justification they need to prolong the stop beyond its legitimate purpose. Here is the difficult truth that needs to be stated plainly. The 3 words work in your favor only when the manner in which you deliver them does not provide the officer with independent grounds to characterize your behavior as threatening, confrontational, or obstructive in their report. After reviewing body camera footage captured during a substantial number of traffic stops, a consistent and unmistakable pattern emerged from that review. When a driver asked the question in a calm, measured, and respectful manner, officers who lacked legitimate legal grounds to extend the stop almost universally allowed the driver to leave. But when a driver asked the same question with visible frustration in their voice, sarcasm in their tone, or with elevated volume, the official report from the officer shifted noticeably. Suddenly, the report reflected that the driver was becoming agitated or was displaying erratic behavior. That kind of documented language opens specific procedural doors. It can justify extending the stop under the premise of a welfare check. It can support a claim of suspicious behavior. It can provide grounds for a Terry frisk conducted in the name of officer safety. You will accomplish nothing of legal value by arguing your case on the shoulder of a road. Legal cases are won inside courtrooms, built on the foundation of clean body camera footage showing a calm, composed driver exercising their constitutional rights with precision and control. The roadside is not the courtroom and should never be treated as one. Every aggressive or combative word you speak at that window becomes material available for the prosecutor to use as an opening argument against you. The wrong version sounds like this. The driver expresses disbelief and asks with obvious frustration whether the officer is serious and whether the warning has already been issued. They demand to know whether they are free to go or not. On the body camera footage, that driver has just provided the officer with a fully documented narrative. The report will reflect that the driver became agitated and raised their voice during the stop. That single observation creates sufficient justification for the officer to remain at the window longer in the interest of officer safety. The correct version sounds like this. The driver thanks the officer for their time, acknowledges receiving the warning, and asks respectfully whether they are now free to go. When the officer asks them to stay put for a moment, the driver states clearly and respectfully that they need to be direct and asks whether they are free to go or whether they are being formally detained. They emphasize that they are asking with full respect. Every single word carefully chosen, delivered calmly, politely, and with complete composure on camera. You present yourself as the reasonable party in this interaction. You are not a threat to anyone. You are a citizen deliberately and lawfully exercising a constitutional right, and your measured tone on camera demonstrates that beyond any question. Cooperation does not require or include conversation. The body camera footage of your calm, clear, and repeated question is the single most valuable piece of evidence your attorney will have available if that stop escalates into something more serious. In states like Florida, Georgia, and Texas, officers carry significant discretionary authority to characterize driver behavior as suspicious. A calm and clearly documented request gives your attorney the cleanest possible foundation from which to challenge any extension of the stop. In states like Illinois and Washington, courts have demonstrated greater willingness to scrutinize prolonged traffic stops, which makes your composed and documented record even more powerful in those jurisdictions. The essential lesson about tone is this: the three words function as designed. The delivery you choose determines whether they function for you or against you. Calm, polite, and repeated as needed is the only delivery that holds up on camera, survives judicial scrutiny in court, and gives your attorney something genuinely useful to work with. Mistake number 6 is not fully understanding why the third word carries more legal weight than most people ever realize, and when that third word matters most in the entire interaction. This is the single mistake that separates people who believe they understand this approach from people who have actually constructed the complete and legally sound constitutional framework around themselves. Most discussions you encounter online focus on two words: am I free? And they stop there without going further. What gets left out every time is the third word, the word that fundamentally changes the legal weight of everything that follows, the word that transforms the inquiry from casual conversation into a direct constitutional confrontation, the word that forces the officer to provide the specific answer you are legally entitled to receive. The complete phrase is not merely a question. It functions as a demand for a legally accountable response. Am I free to go? 3 complete words. 3 complete, free to go together as a unit. Here is precisely why that third word carries more legal significance than most people have ever been told. The phrase, am I free, carries inherent ambiguity. Free from what specifically? Free in what particular sense? An officer can deflect off that ambiguity with considerable ease and minimal effort. But the phrase, am I free to go, removes every trace of gray from the exchange. It constitutes a direct and explicit invocation of your constitutional right of movement. It forces the officer into one of exactly 2 legally actionable positions. Either yes, you are free to go, at which point you leave immediately without delay or further conversation, or no, you are not free to go, which at that precise moment converts the encounter into a formal legal detention and simultaneously triggers your full Fourth and Fifth Amendment protections. Courts have consistently and repeatedly treated the phrase, am I free to go, as a bright-line legal inquiry. When a person who has been stopped asks that specific question, and an officer responds in any manner that a reasonable person would interpret as a denial of their freedom to leave, the Fourth Amendment seizure analysis activates immediately and automatically. Your attorney does not need to construct an elaborate argument about whether the stop was voluntary or consensual. The body camera shows clearly that you asked. The officer said no. The clock measuring the lawful duration of the detention begins running from that exact documented moment. Compare that to softer and more ambiguous alternatives like, can I leave now, or are we finished here? Those phrasings are vague. Officers receive training specifically in handling ambiguous questions with equally ambiguous responses. When you ask, are we done here, an officer can respond almost and continue unimpeded. When you ask, am I free to go, the officer is required to make a definitive legal decision about their response, because any reasonable reading of that documented exchange shows a direct and explicit assertion of the constitutional right to leave. The third word also carries particular significance in terms of how it is captured and interpreted on body camera footage. When your attorney sits down to review the recording, they are actively listening for specific legal language and terminology. Am I free to go represents precisely the kind of language that triggers the Rodriguez analytical framework in a reviewing court. It signals unmistakably to any court examining that recording that the driver understood their constitutional rights and was actively and explicitly asserting them. Softer and more casual phrasing gets treated by courts as ordinary conversation. The precise 3-word phrasing gets treated as a constitutional assertion with all the legal weight that designation carries. Here is a concrete scenario that illustrates definitively why the third word changes everything about the legal outcome. You have been stopped. The officer returns your documents and tells you that you are free to leave. Most drivers at that point simply start their engine and drive away without saying another word. But what if the officer is still standing positioned directly next to your window after saying that? What if the officer says you are good and then does not step back from your door? What if there is a pause followed immediately by a new question, all without you having said, "Am I free to go on camera?" In that situation, you have no documented record of asserting your right to leave. You are sitting in the legal gray zone with no anchor. The officer can subsequently characterize whatever conversation followed as entirely voluntary on your part. Your attorney has no clean assertion to build any argument around. With "Am I free to go" captured, clearly on camera, even in a scenario where the officer says you are good, and then immediately pivots to another question, your attorney can credibly argue that your direct question was never clearly and unambiguously answered, and that the continued interaction was therefore the product of an ambiguous detention lacking clear legal justification. That is a suppression argument your attorney can actually make. That is genuine legal leverage created by three specific words in a specific sequence. The third word closes every gap in the exchange. It eliminates the deliberate ambiguity that officers are specifically trained to exploit and navigate around. It creates a clean, direct, unambiguous assertion of your constitutional right to move freely that is captured permanently on camera. And it forces the officer to make a real-time legal decision that will face scrutiny if the stop develops into anything more serious. So when people discuss this approach using only two words, they are leaving you one word short of complete legal protection. Free to go is the complete legally operative phrase. Learn it in its entirety. Use it consistently and completely. Practice it out loud until it emerges naturally and automatically under pressure. Because the pressure created by flashing lights behind you and a uniformed officer standing at your window is not the moment to be searching your memory for language you have never actually rehearsed. Now let us assemble all 6 of these into the complete unified protocol. Mistake 1 was asking too early before the stop's assigned purpose is finished. Wait until your documents are physically back in your hands. That is your activation moment, and not a single second before it. Mistake 2 was asking only once and accepting an evasive non-answer in return. Ask again and continue building the legal record with each documented attempt. Mistake 3 was remaining silent rather than verbally invoking your rights the instant you are informed you are not free to leave. The words, Fifth Amendment, no consent to searches, and I want an attorney need to leave your mouth and be captured on camera out loud. Mistake 4 was engaging with officer evasion. When the officer drops a new question instead of providing a direct answer to yours, you do not respond to that new question. You re-invoke your rights and redirect back to the only legally relevant question. Mistake 5 was tone. Calm, polite, and measured delivery every single time without exception. Mistake 6 was using an incomplete phrase. Not "Am I free?" Not "Are we done?" Am I free to go? All 3 words together every time without exception under any circumstances. Here are the exact specific phrases to take away from this video and retain permanently. Officer, am I free to go? Officer, I need a direct and clear answer. Am I free to go or am I being formally detained? I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches of any kind. I am requesting that an attorney be present for any questioning. Write these down somewhere accessible right now. Enter them into your notes application on your phone. Say them out loud, repeatedly until they emerge naturally and automatically without any conscious searching. Because in a high-pressure situation, the language you have practiced and rehearsed is the language you will actually be able to produce when it matters most. Here is what the complete traffic stop looks like when you execute every piece of this protocol correctly from beginning to end. You are pulled over. You signal immediately and pull to the shoulder safely. Engine stays running. Dome light on if it is dark outside. Both hands remain on the steering wheel. Window down 2 to 4 inches. You hand over your license, registration, and proof of insurance and nothing beyond those 3 documents. You wait. You do not answer any questions about where you came from, where you are going, or what is inside your vehicle. You wait for the officer to return with your documents and your citation or warning. The moment your documents are back in your physical possession, you state calmly and clearly that you are asking whether you are free to go. If the answer is yes, you start your vehicle and leave. You do not linger for small talk. You do not extend the interaction with a prolonged farewell. You leave without delay. If the answer is hang tight or just a moment, or any variation of a non-answer, you wait briefly and then ask again. You state that you need a direct and clear answer and ask whether you are free to go or whether you are being formally detained. If the officer informs you that you are not free to go, you immediately state out loud clearly and calmly that you are invoking your Fifth Amendment right to remain silent, that you do not consent to any searches, and that you are requesting an attorney be present for any questioning. Then you stop speaking entirely. You keep your hands fully visible at all times. You do not answer any additional questions. You do not attempt to explain yourself or clarify anything. You wait for either your formal release or your formal arrest. If you are placed under arrest, you say absolutely nothing further until your attorney is physically present with you. Not to be friendly or approachable. Not to clear up what you believe is a simple misunderstanding. Not to explain the situation from your perspective. Nothing at all. Your attorney will speak on your behalf in a setting where what you say actually protects your interests rather than creating new exposure. This is the complete protocol in its entirety. This is the full constitutional framework properly assembled. Every component of it is supported by Supreme Court precedent. Rodriguez versus United States governs the timing question. United States versus Mendenhall governs the legal standard for what constitutes a seizure. Salinas versus Texas governs the invocation requirement. Berkemer versus McCarty governs the interrogation standard at the roadside. These are not personal opinions or interpretations. These are the controlling legal standards that govern every traffic stop occurring anywhere in the United States right now. Knowing them and knowing how to apply them correctly is the concrete difference between a driver who walks away from a stop with no additional legal exposure and a driver who spent 30 minutes on the shoulder of a road answering questions that were later used against them in ways they never imagined possible. One final recommendation before you go. Install a dash camera that includes an interior-facing channel. The exterior footage documents what occurred outside your vehicle. The interior footage captures your hands, your facial expressions, your tone of voice, and the exact words you spoke at your window during the encounter. That interior recording is the difference between your verbal account of what happened and actual documented video proof presented in court. When your attorney sits down with the officer's body camera footage alongside your own interior dash camera footage, they have two independent angles of the same encounter available to them simultaneously. If both recordings tell a consistent story, your legal position is clean. If the officer's body camera presents a version of events that differs in any meaningful way from your interior dash camera footage, your attorney has a direct and documented credibility challenge to raise before the court. The body camera rides on the officer's chest and captures what they observe and what they do. Your interior camera captures precisely what you said and exactly how you said it. Both recordings matter independently. Neither one is optional if you want to establish the strongest possible legal position following a difficult or contested traffic stop. Drop a comment below and tell me which of these 6 mistakes you had been making before watching this video today. I read every single comment that comes in. The only way this information reaches another driver who needs it before their next traffic stop is if you choose to share it with someone. One tap is all it takes to send this constitutional education to the next driver on the road who could genuinely benefit from it. You now know the 3 words and you know the 6 specific ways people get them wrong in practice. Use them correctly and you control the encounter on legally documented grounds. That is your right. That is your power. Exercise it. This video is provided as educational content intended to help viewers understand their constitutional rights during a traffic stop. For specific legal advice tailored to your circumstances, please consult a licensed attorney in your state. Traffic stop law varies significantly by jurisdiction and by the specific facts of individual situations. Nothing presented in this video constitutes formal legal advice of any kind.